Okay, ladies and gentlemen, we are going to start right now the next panel, which is devoted to a question which was, as a matter of fact, it's a panel which was requested by James this morning on innovation and technology. And the question is this the next frontier on antitrust for developing countries? Now, this raises a lot of questions. We are going to try to have an interactive panel, and we are going to try to talk about 4 or 5 subtopics under this heading. The first one being how to take into account dynamic efficiencies in mergers in dynamic industries. Second, do we have adequate instrument to take into consideration some of the technological development like multi-sided markets or disruptive innovations? Third, are there specific challenges for competition law enforcement in developing countries when they come to technological industries and to mergers in such industries? 4, is there a question which we already talked about this morning, but is the complexity of merger in dynamic industry, does that lead to strategic use of competition law? And finally, what to do, or should we be concerned about the extraterritorial remedies in IP-related cases, which seems to be an issue that is much talked about. To deal with those issues, we have a wonderful panel. So we have, I can see Elizabeth Kraus over there, who is the Deputy Director for International Antitrust at the Federal Trade Commission. Joanna Tsai, next to Gönenç, who is the Vice President of CRA and was an economic advisor to Commissioner Joshua Wright at the FTC. Koren Wong-Ervin, who is next to her, who is the Director of IP and Competition Policy at Qualcomm. And Gönenç Gürkaynak, next to me, who is the founder of the ELIG law firm in Istanbul, and also a specialist on IP as well as competition, as well as human rights and other topics. So without further ado, let me we start from the big picture, and then we try to focus on the issues of developing countries. And to start with the biggest issue, how can one take into account dynamic efficiencies in merger analysis in dynamic industries? Is this a challenge for competition authorities? And what can be done, or what help can we get? I would like to turn first, of course, to Joanna, because she's an economist, and trying to see whether the economists can have views on how those dynamic efficiencies should be taken into consideration by competition authorities.
Thank you, Frédéric. It's a pleasure to be here. First of all, to answer the question, yes, it is a challenge for competition authorities, and I think it is a challenge for all competition authorities because the exercise is very hard to take into account dynamic efficiencies in merger analysis in dynamic industries. It is hard for everyone. And here's why. Let me lay out why so that we appreciate why it's difficult, and once, when we recognize that, then how we might proceed to resolve it, okay? So it is hard because inherently merger analysis is forward-looking and it's predictive, and we're trying to make predictions of what would happen in the future based on what's happened currently and in the past. So that's the first prong that makes it difficult inherently just with the merger analysis to begin with. Secondly, we're talking about a dynamic industry. Dynamic industries, by definition, evolve rapidly, right? By its nature, it's hard to predict. To the extent that, in a typical merger analysis, if we want to think about market definition or think about competitive effects, what are the substitutes of the different firms' products and services, and how closely do the merging parties compete. Well, all of that gets thrown into even a more uncertainty world when we're in a dynamic industry world where things can change rapidly. So that's the second prong, why it's hard. The third prong of why it is hard is trying to measure or predict dynamic efficiencies, okay? So dynamic efficiencies is something that we want to know the extent to which firms introduce new products, the extent to which firms innovate, okay? So that innovate itself, again, it's predictive, in the merger analysis. So with all these three prongs, I think of complexities, gets compounded, and that's why this is a very difficult exercise, I think, not just for developing countries, for here in the US at the FTC, certainly when I was at the FTC, I know this is a difficult issue that people wrestle with. But I must say, hard doesn't mean that we should ignore it. Hard to account for dynamic efficiencies in dynamic industries doesn't mean we should ignore it. Merger analysis is flawed if only the negative effects are evaluated without the corresponding look at the positive effects from the merger. As example, we can't just look at how would the merger affect the upward pricing pressure on prices without accounting for the kinds of efficiencies and the kinds of cost efficiencies and other benefits that the merger could bring. So speaking of measuring net effects of mergers, I mentioned, we got to look at competitive effects and then we measure efficiencies. Now efficiencies, everyone knows there are various types. Before we get into dynamic efficiencies, there are the more static efficiencies where we're looking at marginal cost savings, and that's part of what we want to take into account in the merger analysis. What's wonderful about merger analysis and mergers in the sense that they could drive lower prices from those efficiencies and better products and more innovation. Sorry, Fred, that was 1 minute?
1 minute.
Okay. So after taking into account cost reduction, normally we want to think about R&D. So what would be one of the benefits that a merger could bring and its efficiencies is the benefits from consolidating R&Ds. And so how do mergers really affect innovation? And would the merger facilitate dynamic efficiency is something that a merger review agency want to look at. And so there lies, I think, a lot of the issues that people wrestled with is economic theory on market power and competition on innovation is a little ambiguous. And there lies a lot of the sort of fact, digging into the facts to understand, for example, when you're looking at two firms merging and they both have an R&D agenda, are their agenda complementary? Or are you, in some cases, and the FTC have looked at this in Nielsen Arbitron, for example, they actually concluded that the competing R&D agenda, instead of sort of measuring dynamic efficiencies from that, they actually thought the merger could have eliminated one of the products that could be brought on in the future. So again, depending on R&D, is it does the merger make facilitate more innovation or less innovation? This could go either way, and it's very fact-specific inquiry.
Okay, thank you very much. Not terribly reassuring. I mean, the theory is ambiguous and the evidence is mixed on how much we can trust the results. So let me turn to a practitioner, Gönenç. You've had experience from that point of view, and do you feel that dynamic efficiencies are taken into consideration by competition authorities at the level that you would like?
No.
No.
The answer is no. Dynamic efficiencies, I think, are being treated inconsistently in the sense that whenever there is a concern about innovation being stifled, then suddenly antitrust agencies all over the world remember about innovation when there is a concern. So products in the pipeline, if you were to come together, are you really going to still produce these products that are in the pipeline and all? But for agencies that are so keen on guarding it as a statical matter, as static being innovation, the same agencies aren't that eager to foster it through promotion of innovation as a policy goal, meaning when it comes to parties defending that, say, for example, short-term distribution efficiencies, losses, short-term price increases are going to be redeemed in midterm or in the long term through innovative gains, suddenly the same authorities that are so keen on using stochastic economical models and so keen on using hypotheticals say, well, this is all very hypothetical, you don't have evidence, you don't have any proof. So, and this has become, I think, very, very inescapably clear in the very, very recent Dow DuPont file, where the authority is so keen on talking about worries that have to do with, I'm talking about the European Commission, the worries that have to do with problems presented by two innovating competitors and whether this would harm their zeal to innovate further as they proceed. Most of the language, if you have reviewed the Dow DuPont decision, relies on very theoretical, hypothetical economic theory. Which there's nothing wrong with that, but they themselves are not relying on fact-based models of economy either. And then when it comes to reviewing the defenses of the parties, suddenly you're seeing a lot of reservation and rejection from the Commission, where the Commission starts saying, well, this is all very theoretical, I want evidences. And this is, I think, part of the fallacy that you have in reviewing innovation-based arguments, which is that innovation is certainly the most significant driver of welfare. There can be no doubt about it. Generations follow each other, and as generations follow each other, the increase in welfare is primarily owed to innovation and dynamic efficiencies. New products, new technology, new business models coming about is what innovation is all about. And yet the idea that we have heard in the morning as well, I know it when I see it, does not really work in terms of treating innovation. Because I know it when I see it is a jargon of problem detection normally. So you are basically saying, I know it when I see it, I know it when I see it when I see a fall, I know it when I see it when I see an issue. But if you wanted to promote innovation as a deliberate policy preference, then you would have to look to see it. You would have to deliberately look to see it, and you can't just say, I know it when I see it, because ultimately you will have to come up with a policy preference of not saying this is your burden of proof, but as an agency you would have to go the extra distance and fear that you might be leading to a result where innovation in the future is going to be stifled through your draconian enforcement. and you should hesitate and you should take baby steps and test the results of your baby steps because you're in a very dynamic and innovative field, which is not really what we're seeing today in the dynamic markets when it comes to merger control enforcement. So if I'm allowed a last sentence on this topic, our situation more looks like the story of the person who's looking for his car keys under the street lamp. Someone else comes and says, why are you looking for it under the street lamp? Did you lose them there? The answer is, well, no, actually I lost it where it is dark, but because the street lamp is here, I'm looking for it here. So the innovation is something that is out there and we know it exists. Whenever it is more calculable, suddenly we start talking about it. In the agriculture markets, in the pharma markets, whenever there is a true pipeline, a clinical test stage of things. And whenever it becomes a bit more evasive, we start pretending as if it doesn't exist, whereas we know full well that it exists. It's just our inability to touch it through the economic models that we have right now, which means that the agencies should be equally eager to listen to all these arguments without pushing them aside as inconclusive, because they're bound to be inconclusive, as there's a degree of prediction and suspense in these analyses with the tools of today. Thank you.
That was a long sentence. Thank you very much.
You're right.
But very conclusive. So on top of the fact that the theory is ambiguous and the evidence is unclear, the standard of proof is not the same when we talk about the anti-competitive effect and the... Now, I had one question, which is whether Joanna was actually working in the same FTC as Liz, because I've always thought that Liz felt fairly comfortable with the method of the FTC when it came to dynamic efficiencies, whereas Joanna has expressed the fact that the FTC was very difficult. I mean, we didn't know what we were doing. I mean,
No, I mean, I think it's a hard exercise. I wasn't saying anyone didn't know what they were doing. I would like to, take another round at this.
Okay, yeah. So let's have Liz first,
Liz
and
first,
then you.
and then I'll
Liz.
elaborate.
Hi, and since I am here with the FTC logo, I should give the disclaimer that I'm speaking on my own behalf and not on the behalf of the Commission or any of the individual commissioners. And I also wanted to just use this moment to thank everyone for providing some really provocative thoughts this morning. It's been a really interesting conference so far, and I'm really delighted to have been able to join and hopefully will offer some additional as well. And so I actually wanted to take up most of everything that Joanna just identified. It's a hard, difficult exercise, merger review to begin with in innovative markets with disruptive innovation. It's all very fact specific, it's predictive, and then you get into the efficiencies of it all, and it's the tools are not always there with the precision that we would like. So I'd want to step back a moment and say dynamic efficiencies aren't the only way that we bring dynamism and looking at innovation and evolution of markets into our analysis. And it's very rare, actually, for us to do a deep dive into dynamic efficiencies in our merger review. We often look at dynamism in other parts of our merger review exercise first, when we're looking at whether or not there's even an anti-competitive concern. We'll look at market entry, we'll look at market definition, and we can, in very many instances, either overcome the issue of the competitive concern and therefore not have to go into the dynamic efficiencies, or we really do find issues and then we'll listen to the justifications that the parties would want to provide on the dynamic efficiencies, because it's quite important to look at the legitimate rationales of the transaction and make sure we're not negatively impacting a market without reflection as to what those are. So how do we do this, maybe, would be helpful. And I think many of you know that in the US we have horizontal merger guidelines, and in Chapter 10 we have the approach to efficiencies. And we're going to be looking to see whether the efficiencies that are identified by the parties are going to be merger specific? Are they vague or speculative? Are they cognizable, by which we mean can they be verified? And that gets a little tricky with dynamic efficiencies, as Joanna identified, and that they're not arising from anti-competitive reduction or output. So the challenge for us is really this latter point about vagueness and cognizability, I think. And you can see that in the research and development area, for example. There's a nice passage in the guidelines that identifies that there can be really substantial cost savings, and yet they might not be cognizable because they're really difficult to verify, or it might be resulting from anti-competitive reductions in innovative activities. So you might be combining two potentially competitive approaches to research and development, and then we'd be worried about that. If we do see, though, that there are cognizable efficiencies, then we'll look and do kind of a broad brush balance against the anti-competitive harm. And if there's limited anti-competitive harm and the magnitude of efficiencies that we're seeing are substantial, we would let the transaction go through. Is that rare? Yes. In our litigated matters, parties have had a really hard time in court developing the efficiencies arguments and having those claims accepted. We note, however, in our commentary, I think it's in 2006, to the horizontal merger guidelines, we give a couple of examples of where the magnitude and the efficiencies might prove meritorious. And then there's one case from 2004 in a consummated merger, Genzyme Novozyme, that's it, where we really did do a look in an innovation market for drugs, which the two competitors for the therapy that they were doing research and development into were merging. And in the pipeline drug issue, you'd have considerable concerns about that. In a consummated merger, you actually have a little bit more evidence, maybe. And there was some pointing to the fact that post-merger, Genzyme actually supported the Novozyme research and had other benefits that were complementary, such that the dynamism of the efficiencies actually overrode the competitive concerns. But again, I'd underscore that's rare.
Joanna, you wanted to come back?
Yes, so just a brief intervention. So I just want to reiterate that hard doesn't mean we should ignore it, and because it's hard, just like Gönenç said, is probably why it's not taken into account enough, because it's hard to document, it's hard to quantify, and all the such. On the other hand, anything that, whether it's competitive effects or efficiencies, they ought to be evidence-based, as Liz said. And even in the cases of static efficiency, it's hard to document, not to mention the dynamic efficiencies. A lot of times parties have trouble because it's something that's hard to document and prove, even for cost reductions. You could prove, potentially these types of cost reductions, but are they cognizable, right? And, and whether, the parties, for example, have had similar types of mergers and can document that they were able to bring about those kinds of cost efficiencies. And that doesn't happen in every scenario, and therefore it's difficult. But in terms of R&Ds and pipeline scenarios and merger analysis, I just want to say it's not that everything is up in the air and we just can't do anything about it. And there are questions that I would look into that I think could help to, it's not precise, it's not perfect, but it could help to give some indications as to how worried we should be about, pipelines, in the context of a merger and things like that. So first of all, just maybe this is a longer intervention than I anticipated. Product and development, are there what are exactly the overlaps in terms of function and use? How closely would they compete if the products in pipeline would actually get brought onto the market, right? And then the probability of those products actually, getting to market. Because if we're expressing this as a concern, right, of eliminating future competition, then we ought to sort of understand what stages these products are at and what are the probability of them getting into the market. In some types of industries, like pharma, there are better statistics that we can use. For example, products that get to clinical trials, that get to phase 1, 2 versus 3. There will be something to that effect that we could use to try to predict how likely these products are to get to the market and whether they would be real substitutes, between the two merging parties' products. On the other hand, it could be the case that by consolidating R&D operations, they're not substituting each other's innovations, but they're actually then becoming a stronger research team, being able to bring about more innovation.
Okay, thank you very much. So it's a pragmatic approach. It would be fair to summarize all this by saying we do the best we can. We don't really have analytical tools which are very sharp. We have some tools, but we look at each case. Now, let me turn to a second topic, which is the fact that in high-tech industries, particularly in the digital world, we have new forms that emerge, such as, for example, multi-sided markets. We also have, partly in the digital economy, but not only in the digital economy, new forms of innovation, such as disruptive innovation that take place. So the question is whether the tools that we have, even for the let's leave aside the dynamic efficiency for a while, but whether the tools that we have just to study the competition implications of certain transactions are adequate to deal with those new forms of competition. So let me turn to Gönenç again, to see whether you believe that competition authorities have adequate tools to deal with those new forms of markets and new forms of innovation.
Not yet, I think.
Not yet.
And I think the rule of the game will have to be, while waiting to develop these tools, that we should follow the Hippocratic Oath, basically, primum non nocere, first do no harm. So because we don't have these tools in the disruptive innovative markets, we shouldn't resort to the traditional tools that we have in enforcing, as the perverse results of these would be far worse for these markets than lack of any enforcement, in my view. So if the SNP test is not working, because it is designed to analyze single prices in one-sided markets, and what you have is a zero-priced market or a multi-sided market, then you should just abandon the SNP test in that particular instance, and maybe make peace with the fact that you should self-doubt as to what you're doing and how you're defining markets. It is not ideal. Clearly, there will be a day where we have better analytical tools, but in these transition periods of markets taking the lead and competition lawyers and competition economists trying to catch up with what the markets are coming up with, it is far worse to go at it with the traditional brick and mortar theories of or tools of enforcement. An interesting example we're seeing in Turkey, you might be interested to hear. I try to not give Turkey-specific examples to you because it's not a leading competition law jurisdiction, although the enforcement is pretty sophisticated now there. But this is truly interesting from a global perspective as well, because to my knowledge, this is the only case of an excessive pricing allegation in an online market. The Turkish Competition Authority is pursuing an excessive pricing case in the online ads market. And this is a perfect example of why you should abstain from the traditional tools. What the Turkish Competition Authority is doing is they're deploying the cost analyses that you would normally do, and then they're coming up with all their ideas about how the prices have increased in the last 5 years, and they're saying this price must be excessive because I'm looking at your costs and you don't have much of a cost, do you? And the defendant is trying to frantically explain that that's not the business model and that's not how it works, and you're catching me at my moment of recoupment, and actually I'm going to convert this recoupment into something in this industry if you were to allow me. You see, we're coming back to the first do no harm kind of approach. Admittedly, this is an emerging market example, so the more developed countries are not doing this type of enforcement, but still I think it gives a good example as to how we should treat the question of what to do in multi-sided markets of disruptive innovation, or multi-sided markets per se, and that should be first do no harm.
Okay, thank you very much. Well, let me turn to Joanna. As an economist, do you agree that traditional instrument can fail? And as an economist, do you have a way to retool those tools to make them more relevant?
So I must beg to differ somewhat from my fellow panelists.
To me a lot.
Huh?
That happens to me a lot.
Just to make it more interesting, right? Just for a second. So maybe it's sort of what we mean by tools, right? Because that can differ. I think that the tools are there. We might need to hone it in a little differently because of the industries that we're looking at, and also that, you know, we need to implement it and interpret it differently. The interpretation and implementation is different, but I don't see it as necessarily needing different tools to evaluate multi-sided markets. And I'll give some examples. So I think Gönenç mentioned a situation where you have a multi-sided market, and what is very common we see is on one side of the market, the price is zero or even negative, right? And so antitrust agencies may be tempted to, or complainants, right? Other complainants can be tempted to say, well, you have literally no cost or very low cost. Why is your price so low or so high, right? So antitrust agencies could be concerned about either direction, prices that are significantly higher than cost, or significantly lower. Significantly higher because it's indicative of potentially abuse of market power. Significantly lower could be a predatory pricing type of framework. Now, with that, I would say, one of the things that, that then the whoever is looking at this and reviewing this ought to realize that this is a multi-sided market. So it's not the case that cost is as low as they are. They are, one side is subsidizing another side. And that ought to be taken into account almost as a system, right, as a platform, as opposed to just, focusing on one side and cut out the rest of the sides. Another, and you also mentioned the SNP test. The SNP test, so, to that, the SNP test doesn't work if you just focused on one side, as opposed to looking at the prices at various sides, or looking at it, again, a SNP test as a whole system, as a whole platform. And another thing to consider is and this is something that, it's not just me sitting here saying, I think the literature on this, and the FTC actually has something on this as well, is that, you look at another way that one could examine effect would be to look at output, look at transaction volume, right, as opposed to prices, because prices is hard to think about because they're being divided up, on the different sides of this market. So that.
I understand that, just to come back to what you just said on the SNP test, for example, that you want to take it you want to take the globality of the two sides, but how do you allocate exactly the hypothetical increase in price? Do you allocate it on each side, proportionately, or in other words, when you say, well, we need a little twinkling of the tools, I want to know, is there an agreement among all economies on exactly how you should do that? Or is that still a debate?
It's really hard to get all economists to agree. That's
anything.
on anything, just as just to begin. And I wouldn't dare say that all economists agree on how you would do that. What I can say is, I think, at least one other economist other than myself, how about that, would at least say you would look at a SNP test on one side of the price, on the other side of the price, on joining, the prices on the various sides, and observe where you might, have problems, and sort of taking them, together as a whole, as opposed to ignoring the rest.
No, I understood that. Okay, yes, Koren, you haven't spoken yet.
Sure. So, going back to what you said on the last question about, a practical approach, right, for considering dynamic efficiencies, and now we're sort of, it reminds me, so the last 2 years I had the privilege of traveling the world and training foreign enforcers and judges with Judge Ginsburg and Josh Wright, and, it really let me know how much I don't know, and how much I don't know exactly, how much I rely and need the economists. And so, we would go abroad and train folks, mostly in Asia, and, they would ask, how do we consider, dynamic efficiencies, like, or how do we consider, and without having PhD economists or even a pool, like in India, they were saying we don't even have a pool of IO people to draw from to recruit to the agency. I don't know, I was asked questions like, tell me, like, they have a pen and paper, tell me how to do it, give me sort of a formula. And so I think there's a real desire to do sort of, effects-based analysis in the right kind, across the world, but I don't know how people do it without you've heard that even at the FTC, when they, with I don't know, 70 PhD economists, it's very difficult. So I think, we're talking today about like what should be done, but sometimes, I really learn, sort of the practical, what can be done.
About a partial answer for you, because we did organize at OECD last spring a meeting with, 10 or 15 economists to try to get them to tell us how to do it, how to improve. And we are about to publish a methodology. And the reason for doing this was that competition authorities, even though they always say that they have the tools and that they don't need new tools, which everybody agrees, but they need to have better tools than the ones that they have. If you think about the payment card system, for example, and if you look at the decisions throughout the world, for 10 to 15 years, there were decisions which were absolutely contradictory with each other. Nobody understood how those markets worked, and the analysis was exactly what Gönenç was warning about. Competition authorities went right ahead and made decisions, and those decisions didn't make a lot of sense. So to try to avoid this, we've been trying to get the economies to agree. Liz, now, maybe at the FTC, you already know everything there is to know.
I don't think we know everything there is to know, but I know that we work hard to try to figure it out. And we talk to parties, and we listen to kind of what we're missing and why, and try to take that into our analysis. So that leaves me with the impression that our antitrust laws and the framework are sufficiently supple and flexible to be able to accommodate these types of issues. That's not the end of the story, though, as you rightly point out. And I think kind of work like the OECD was doing on getting economists together to see what tools there are is important. Our own work and developing the resources internally, not just with economists, but in understanding the markets, how they're evolving, and how we might interact with them in our enforcement is really important. And what do I mean by that? It's not just lawyers, it's not just economists. It's having people who understand patent law. It's having at least access to what we've developed as a chief technologist We've added that to the ranks of the FTC. We also have an Office of Technology Research and Investigations. And by developing that underlying understanding of how things are moving, I'm hopeful that we can help to move our tools and be better at predicting how the markets will work in our enforcement.
Okay. Very good. If no one wants to intervene on this, let's try to move to the third issue, which is, do those problems that we've been agitating, assessing dynamic efficiencies, assessing competition in high technology markets, do they create specific challenges for competition authorities in developing countries? Now, I'm going to turn to Gönenç, and I'm sure that you are going to talk about Turkey or maybe some other country, developing countries that you've been familiar with, to give us a sense of what is your appreciation of the difficulties and or the level of sophistication of the analysis in this area in developing countries.
In developing countries, and yes, I am using the Turkish model, but also in the region. You just came back from Kazakhstan, so in the CIS region as well, in the Gulf, I'll call them aspiring competition authorities jurisdictions, and also in jurisdictions where the competition law is quite sophisticated. In Turkey, it has been around for 20 years. The Turkish Competition Authority has about 150 case handlers. And there's quite a sophisticated competition law bar as well. But the authority doesn't have the same tools that some other more sophisticated agencies have. It doesn't have enough economists that can pull a sophisticated competition economics analysis, for example. But to make a long story short, I think the biggest handicap that you see in the developing markets is that you see or hear a lot of lip service paid to innovation, because they do follow the global trends. So you hear innovation, dynamic efficiencies, ooh, yes, this is very important. But actually there is a bit of a despair in the sense that in the developing markets are never the originating jurisdiction of such innovation. So they have never touched and felt the frontier innovation. So innovation is an obscure thing for these jurisdictions generally. And when it comes to explaining to the bureaucrats and the public policymakers that it doesn't have to be cutting edge frontier innovation, building capacities to mimic the innovation of others is also innovation for our purposes in the developing markets. It's equally important to make sure that we can adapt innovation of others into our own markets and transfer that, and that also takes a policy preference, and that also requires the zeal of the authority. That's a different ballgame. I think they get lost very easily, most of the authorities, in the gravitas of the term innovation, and oh well, we're not doing the innovation, so clearly the more sophisticated jurisdictions, authorities will come up with policies and we will follow that. Whereas the developing countries' authorities will have to develop their own approach toward how they can build capacities within their own spheres of influence in transferring these innovations that are happening elsewhere, in adapting them so that there is the quote-unquote catch-up process, which will, in the midterm, hopefully lead to true innovation in these jurisdictions as well. And of course, there's a vicious circle in most developing countries in the sense that there are poor business models, there isn't enough educated people, there's political instability, governance conditions are not very good, and there's an underdeveloped infrastructure. And the vicious circle is that part of it can be helped through innovation, but also these are the very factors that are stifling innovation in the mimicking sense as well. So to attack that issue, obviously there has to be a very sober policy about what the developing countries' public policy makers want from innovation, and they will have to define their own animal of innovation, and they will have to get rid of the giant ideas of, well, you know, it's not like we're going to bring a new breath to protecting innovation from Turkey. It's the job of the enforcers in the US and the EU and the French authority and the Bundeskartellamt, and we will only parrot what they're saying because it's not our innovation to protect. It shouldn't be that easy, actually.
Okay. Do you have any concrete examples or cases that you want to?
I do. A couple of Turkish examples would be, for example, that there are instances where very easily Turkish authorities have adopted the conditions that were provided by the Commission in merger control cases, or they have not tailor-made some of the pieces of enforcement that they came up with. These are continuing cases right now as well, some of them, where you see that the authority is almost carbon copying what is happening in the EU in Turkey, whereas you can feel that if they were to have in mind their own idea of policy making and what they want to get out of this, they may steer it differently, they may mold some of the conditions differently, and it's just too quick and easy a label to say, well, there's already the pre-made condition there, I'll just heat it and serve it as the dish that also satisfies our needs.
Take from the shelf and just
Yeah.
apply it. Okay.
Yeah.
Koren?
Sure. So, I mean, I guess, you know, I've been, like I said, in a lot of different jurisdictions where, you know, so I think recently there was reports that India is now the largest smartphone market. It's overtaken U.S. and China is first. And, you know, so, but yet China and India, you know, are still primarily implementers, not innovators. And so I've been to a lot of conferences in India and elsewhere where there's a lot of talk about what can the government do to create sort of new innovations, right? And so for me, that you know, I'm puzzled by that because I think, you know, it's the promise at least, or at least the promise of the possibility of monopoly profits, at least in the short run, you know, that incentivizes innovation. You know, and when I think about dynamic industries, at least, you know, many of them, you know, I think about the difference between competition for the market and competition, you know, on static sort of price output in the market. And, you know, when you have like leapfrog innovation, dynamic, you know, innovation, it's the winner take all. And so necessarily you have to have some sort of short run market power. That's you know, something that's necessary for the consumer benefits that come. It's not a market failure. And you also, you know, as a natural feature of you know, these sort of dynamic, you know, leapfrog innovations is that you have you know, you have high rates of return, at least for a short period of time. And again, you know, so getting, I think, certain jurisdictions to look at, you know, market power and high prices as okay for a period of time, as something that might be necessary to incentivize the next best thing, I think is difficult. Mm-hmm. But I think, you know, it's important for emerging jurisdictions, just like all, to really resist the temptation to apply some sort of, you know, formalistic rules or truncated analysis when you have something that's new and you're not, you know, and high concentrate, or, you know, or you know, large market shares, and really, you know, stick to the basics and do the sound economic effects-based analysis.
Okay. Well, let me turn to Liz again. In your capacity as the international arm of the FTC, you do cooperate with a lot of countries and developing countries. Do you see that there are, or what kind of specific problems do you see in the evaluation of mergers in high-tech industries in developing countries?
Sure. Before I get there, I actually wanted to step back and speak just for a second on the advocacy role for the agencies, because I think it's really important, and I was so appreciative that we had Marta's discussion as the keynote to focus on this, that there are considerable challenges with regard to government regulation that limits entry and incentives and innovations, and it's just a huge role for all of us to be able to participate and help to set the policies right to allow for more competitive markets before we even get into the enforcement. It's important for us. We have a lot of work going on at the FTC right now, but also it's really important in developing countries where the issues might not be well understood outside of the small competition community. So I'd start with that and then move into enforcement, which is where your question went, Fred. And in addition to some of the factors that we've heard in doing some technical assistance and having bilateral relations just around the world, we see a number of different other factors. One might be just limitations in the legal systems and tools. The people who developed the laws initially might really not have understood to the same degree that we all do in this room how competition enforcement might work. There might be a lack of a pre-merger review that agencies can't get, like in Egypt and Indonesia. There might be the ability, they might not have the ability to compel documents effectively, or there might be, say, per se approaches in unilateral conduct which make it very difficult, outside of the merger context, but for agencies to assess innovation and dynamism. Other elements might be they might not have the legal tradition or necessary procedures to really sit down with parties and understand what pro-competitive justification and what the innovations and what the investments are in order to get there. Staff may not be steeped in market economics yet. A lot of folks, as we heard earlier, coming from pricing regulators, and there's a transition period. Others, they might be besieged by complainants or politicians who are extraordinarily enthusiastic about using a new competition system and not really knowing what that competition system is supposed to be providing, or really trying to use that new tool to address market dislocations, like we've heard employment, but maybe of incumbent competitors as well. So we see all of this, and a new agency is, really faced with just many different and almost overwhelming odds, and yet, it's really impressive to see kind of how many agencies are able to work within that system and refine their approaches and get changes to the laws and help to move up the antitrust curve. And it's here where I would just identify, I think for all of us, that we can have a really important role there, particularly with dynamic industries, because it's given the timing of the issues in dynamic industries, they're dynamic, and the fact that they often involve worldwide markets, we can really help to exchange information and learning. That can happen through case cooperation. It can happen very much through the work of some of the international organizations like the Competition Committee that Fred leads in OECD, like the ICN, in developing best practices, essentially. So they're kind of cheat sheets so that folks know what to look at. We can help with investigative process. We do a lot of that through our technical assistance program, working to have resident advisors on the ground to work in cases as the staff is working through them is really helpful to exchange views on what to take into account, what's your theory of harm, how are you going to address that. It takes time, but hopefully we can move that along. And I think it's also part and parcel, since there are so many private practitioners in the audience here, I would kind of put out a pitch to them as well, that they can effectively participate in that learning curve and that process. Commenting on laws, even using your cases to help educate some of the elements that the antitrust agencies might not naturally focus on.
But are we in a case where you're saying something which is in fact quite different and maybe slightly opposite to what Gönenç was saying? In other words, my understanding of what Gönenç was saying was that a developing country may have or maybe should have a slightly different focus when they look at innovation than developed countries, because the innovation, as he explained, comes largely from the developed countries, whereas the catch-up is really the dynamic part. And in that sense, the kind of exchange that you suggest, isn't that going to steer them towards the traditional view of the developed country? I mean, lead the developing countries' competition authorities to kind of have the same view as the competition authorities in the developed countries, rather than developing their own notion of what would be useful for the catch-up, which would be their ability to innovate or the capacity to innovate. Okay. In other words, how did you react to Gönenc's
I reacted to Gönenç in the sense that you can use a number of the same tools and approaches and have different circumstances on the ground that might get you to different places. Yeah. Your market structures might differ. And so you can, I think there's a way of definitely uniting both elements and having a coherent, more universal approach at the basic level.
But when you said we should exchange what to take into account, I mean, isn't that slightly ambiguous? In the sense that, I mean, if we talk about market definition, I mean, that's very clear. If we talk about innovation or the innovating part, that might be seen differently from developing country perspective, as outlined by Gönenç, than the developed countries' perspective.
It might, but again, I think it goes back to the factual circumstances that are going to be experienced. So is the innovation going to come to the other jurisdiction in 10 years or versus 1 year? And how do we account for that within the model that I think we can both use?
Okay. Joanna, you wanted to intervene in this debate.
Yeah, I just in a sense, following up to what Gus was saying and also what you had asked, Fred, is that I think they're in harmony in the sense that the way I view it, because it is the tools that gets, and again, everybody has a different notion of what tools mean and what they include. But I can see very well, I mean, I know when the FTC goes abroad, economists go, as well as, well as lawyers sharing their experiences and the tools that are used. And in my personal, and that can be, then, applied to the different circumstances in each of the countries. Now, in my own work, working on cases in emerging economies, my experience has typically been that a lot of times the theoretical framework or underpinning, there's understanding there, but sometimes what it comes down to is quantification and how to do that. And therefore how to get to the final conclusions. And this is particularly important when you, for example, have a merger with horizontal elements as well as vertical elements. And so you might have effects on prices that are going in different directions, and how to quantify and try to get an estimate of what the net effect would be. That's, an example of something that I've worked on abroad, in an emerging economy where I, sort of try to demonstrate how I, as an economist, would do that. And then, or separately in the issues of geographic markets, for example, right? I mean, we know what it is, and, enforcers know what it is, but exactly when it comes down to when regional geographic markets are at issue, or maybe even worldwide versus China, on IP, cases, how do you go about thinking about how to implement it? Whether you're thinking about it in terms of geographic markets around the users or around the suppliers, these are some of the more practical issues that I think, once there's the tools in place, it will be the next step to implementing it in an appropriate way to each country.
Joanna is a firm believer in the usefulness of economic tools and the transmissibility to all countries and developing countries. But okay, I think that you made your point. Given some of the uncertainties which have been outlined so far in measurement, if for no other reason. Can we go back on the discussion which took place this morning